Hello, welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and a partner at the Edwards Wildman Palmer law firm in Boston. The IEEE is presenting this podcast in conjunction with a series of articles that I co-authored on legal issues relevant to people in the computer hardware, software, networking, and service businesses. These articles are appearing in the IEEE's computer magazine each month in 2012. This podcast is part 5 of our series. In the last podcast, we discussed what to do if you're sued for patent infringement. In this podcast, we will cover what to do when the U.S. government initiates an investigation of your business. Joining me today for this podcast is my colleague, Stephen Huggard. Steve is a partner in the Boston office of Edwards Wildman Palmer. Welcome, Steve.
Thanks, Brian.
Steve, it has to be unnerving when the government agents appear unannounced at a business to conduct an investigation. What are the agents authorized to do, and how does a business deal with this?
Well, Brian, you're absolutely correct about it being unnerving. In fact, the agents count on the fact that you'll be somewhat unnerved. I'll tell you that I was a prosecutor in the Justice Department for 17 years before I joined the firm, and so I have a fair amount of experience on both sides of this issue. Agents often want the element of surprise on their side, because they know what they're asking about, what they're interested in, and you don't. What they're authorized to do depends on where the investigation is. They may have a subpoena, in which case they're just serving you with a subpoena for records, which means that you have to produce records by a certain date. They may have a search warrant, which means that they're allowed to enter your premises and come in and conduct a search for evidence. Or they may just want to interview you or your employees, which means they just want to talk to you. One of the things, that's what they're authorized to do. What you're supposed to do is you're supposed to, A, be polite. There's no reason to make them angry. They're just doing their job. Second, you should ask them what they want. Why are you here? What can you tell me about what this is all about? And then third, you should tell them you want to talk to your lawyer. Many people think, well, someone shows up with a badge or a badge and a gun, and the gun is supposed to be hidden, but sometimes you can see the bulge and you realize it's there. That this man's got a badge or this woman's got a badge, I have to answer her questions. Well, no, you don't. And you might think, well, who's going to show up at my business? I run a good business. I go to work every day. I'm an honest person. Anybody could show up at your business. The FBI might be there, the IRS, the DEA, Postal Service. Anybody could show up looking to talk to you or your employees for reasons either pertaining to your business or pertaining to another business, maybe your customer's business or someone who's one of your suppliers. In any event, it's almost never a good idea to talk to them right then. That's what they want. That's not what you want. You want to take some time, get a deep breath, consult with counsel, and then if you're going to talk to them, have a conversation that you can control at least a little bit. But if you do talk to them, the number one piece of advice that I could give you is if you do talk, and I usually recommend that you do not talk, but if you do talk, make sure you tell the truth. Lots of people think, well, I can just deflect it a little bit, I'll give a half a truth, I'll say it somewhat, and I'll get them to go away. Well, this isn't your next door neighbor looking for you to return the chainsaw you borrowed. He's not going to be deflected easily. This is a professional investigator who is about his business, who does this every day. And if you're trying to deflect him with half a truth, the odds are good he has some documents that will tell him that this is a half a truth. And now you've gone and made him very suspicious. So my first piece of advice is don't talk. My second piece of advice is if you do talk, make sure you tell the truth.
Typically when these things occur, I think the scenario would be that the agents will show up at the front door of the organization, of the business, and confront a receptionist or a clerk or somebody who's certainly not in command of the business. What's the best approach for her or him to take when confronted with those agents at the front door? Who does she contact? What does she do next?
If the company has a general counsel, and many companies do not, but if the company has a general counsel or any kind of in-house lawyer, the receptionist should automatically contact the lawyer. That's who the receptionist should call. If not, the receptionist should call the most senior person in the company. Most people at a senior level are going to be unnerved anyway, but hopefully they will have the gravitas and the the understanding of the situation, that as they're walking to the front door to greet the agents, they can compose themselves and figure out how they're going to handle the situation. What the receptionist should not do is just say, come on in, go, Joe's office is down the hall, you'll find him down there, and unless they have a search warrant. If they have a search warrant, they're not really stopping at the receptionist, except to say, we're coming in, and they're going to be past the receptionist in a heartbeat. But if they're there just to interview people, the receptionist should not be saying, Joe's office is the third one down on the right, just knock on his door and walk on in. They can sit in reception just like anybody else, and they can wait to have someone come out and greet them. If they're asking for someone individually, if they're just want to talk about the company, get the lawyer or get the senior-most person.
If they come in just to interview people, are the company's senior executives or in-house lawyer allowed to accompany the agents on these interviews? And how long can these interviews take? It can be very disruptive for a full day of interruption to a business, for example.
Well, when they show up at your door, you really don't know how long they're going to be there. If they're there to serve a subpoena, they might just be there and gone in 5 minutes. If they're there with a search warrant, they're probably going to show up at dawn or close to it, and they might be there until midnight that night. They will be there as long as it takes. And when they show up with a search warrant, they will take control of the premises. You're pretty much out of business for the day. And they will take whatever records are called for in the search warrant. You should contact your lawyer immediately, and your lawyer can come to the premises and interact with the agents and try to get an understanding of what the search warrant calls for and what they're taking. One of the big issues, obviously, is what do they do with your computers? They are allowed to search your computers. Most times these days, they will take a mirror image, which is better for you because it allows you to be up and running again the next day. If for some reason they can't take a mirror image, they will take the computer. And you really don't want them taking your computing equipment. It's much better to have them take a mirror image. You will find a search warrant to be horribly intrusive. You will feel like you've been raided or invaded. The agents don't see it that way. They're just doing their business. Most of them are professional, assuming that they don't have to force entry into your premises or any compartments within your premises. Your premises should be left relatively undamaged, although somewhat emptier of records when they're done. But you should not get angry. And it's a real understandable reaction for people to get angry when someone comes into your premises and puts you out of business for the day. But anger is completely counterproductive.
You mentioned earlier about interviewing and questioning employees and so forth. And as you alluded to earlier, some people feel very forthcoming when they're being questioned by somebody with a badge. And could you explain a little bit more about what an employee could do if an agent or an investigator is escorted to that employee's cubicle and wishes to have a conversation? Is the employee compelled to talk? Does he have a Fifth Amendment right that he can assert at that point? What are his options?
The employee is never compelled to talk in that situation. Whether the employee wants to assert a Fifth Amendment right, I would generally say don't mention the Fifth Amendment, because that just tells the agent that you're guilty. So, but you can just say, I'd rather talk to you after I talk to my lawyer. I'm sure we can work something out, but I want to talk to a lawyer first, and then we'll arrange a time to speak. Lots of times when they're conducting a search warrant, the agents will simultaneously be out at people's houses trying to interview witnesses. Oftentimes, they'll be at the business as it opens or just before it opens, and they will try to get to key employees' houses before they've left for work. So you, as a business owner, have a hard time coordinating the response because it's all happening at the same time. That's obviously what the agents want. It is better to have a general understanding by the employees as to what they should do if they're ever confronted. Of course, that's a difficult training to hold. If we're ever the subject of a search warrant, here's how you react. It's not a standard training, nor should it be. But I think it's important for people generally to understand that they should always contact a lawyer before they're speaking to law enforcement.
In the scenario I just described, let's say, for example, the company has its own in-house lawyer who's also accompanying the agents around. Are there any issues with the employee relying on the company's lawyer, or should the employee perhaps just put a stop to any further conversation and get his own attorney to consult with?
For purposes of that day, well, the chaos of a search warrant is reigning. It's okay, but for the company lawyer is not the individual's lawyer in most cases. And in most cases, the individuals will need separate counsel. Usually, although not always, the company will pay for those lawyers. People should understand that criminal, especially federal criminal cases, can get extremely expensive to defend. And most individuals do not have the capacity in their own bank account to afford such representation.
So in dealing with these types of issues, or at least preparing for these types of issues that could come up, is it advisable that a company draft as part of their policies and procedures how to deal with these types of things if the company is served with a subpoena, or as you say, it's a search warrant? Are these things that can be found in a procedures manual?
There are some things that can be done ahead of time. First of all, the company should have a good document retention policy, because a document retention policy is not only a document retention policy, it's also a document destruction policy. It says that all documents will be kept for a certain period of time, which means that older documents are no longer kept. This limits the amount of material that is subject to production pursuant to a subpoena or pursuant to a search warrant. That being said, once a subpoena or search warrant is served, it is too late to put in place a document retention policy. You cannot say, well, we're going to get rid of everything that's over 6 months old. At that point, you're committing another crime. You're committing obstruction of justice, among other things. So once it's been served, once you've received the subpoena or you've been subject to a search warrant, do not destroy documents. Do not delete emails. Do not go back and try to clean things up. But if you have a regular policy that allows you to keep your files orderly, and you just follow that policy, that can be quite helpful if there's ever a government investigation. Also, you should have a clearly defined policy as to who speaks for the company. If the media contacts us, if the government contacts us, these are the people who should be contacted. And if that kind of piece of paper that is policy is out at the receptionist desk, that will help the receptionist in answer to your question earlier.
Thanks, Steve, for your views on this. We hope you found this podcast helpful in understanding issues surrounding government investigations of businesses. Stay tuned for our next installment in Computer Magazine, which will cover open source licensing. Until next time, this is Brian Gaff.
And Steve Huggard.
Feel free to contact us via email at bgaff@edwardswildman.com
or at shuggard@edwardswildman.com.
Thank you.